Is there appeals in the matter of O'Hanlon and Information Commissioner and another?
Yes, Mr. Tabori.
Mr. Metcalfe, in fact, my lord.
I'm sorry.
I appear for the first appellant, the Information Commissioner.
Oh, I see you're doing it in that order.
That's the order that Mr. Tabori and I have discussed.
Right, that's fine.
He is, of course, for the executive, the second appellant.
Yeah.
And my learned friend, Mr. Lockley, is for Mrs. O'Hanlon, who is the appellant below and the respondent here.
Yes.
First of all, housekeeping, my lord. You should have 4 bundles.
Yes.
A core bundle for the Commissioner's appeal.
Yeah.
A core bundle for the Executive's appeal.
Yes.
Supplementary bundle from Mrs. O'Hanlon, and a joint amended authorities bundle.
Yes.
You should also have 2 sets of skeleton arguments. The replacement skeletons of the parties are in the respective core bundles, but each of the parties has since filed a supplementary skeleton. In terms of the running order, I have 2 grounds of appeal to address to the Commissioner. My learned friend, Mr. Tabori, for the Executive, has only 1, but like the hedgehog, it is his best. Given the overlap between the appeals, I propose to deal with the Commissioner's first ground, which is the public interest timing issue. And Mr. Tabori will deal with the meaning of holds, which is the issue which is common to both appeals.
Yeah.
Turning to the first issue.
I should tell you that we have read the 2 decisions of the tribunals. We've read the skeleton arguments and we've read the regulations.
Well, I'm very grateful, my lord, and if there is any point at which you would wish to usher me along and hurry me up, by all means, please indicate that. The first question is, of course, the correct date for assessing the balance of the public interest under Regulation 12(1)(b) of the Environmental Information Regulations, and the application of any exceptions under 12(4) of the regulations. For the Commissioner, we say the date of the public authority's original refusal, or the date by which the public authority should have issued its decision in accordance with the regulations, whichever is the sooner. Mrs. O'Hanlon, however, says that where a public authority has received representations from an applicant under Regulation 11, the date for assessing the application of any exceptions and the balance of the public interest becomes the date on which the public authority reconsiders its decision. And that is what Upper Tribunal Judge Citrin decided below. This is a matter of construction, first and foremost. There is no authority directly on point, although, as you can see from the skeletons, there are a number which are of persuasive assistance. It's also common ground between the parties that the regulations, the Environmental Information Regulations, seek to implement the directive. The Commissioner also accepts the point...
Regulations are made under Section 2.2 of the European Communities Act.
Yes, Madam. And the Commissioner, in respect of that, the Commissioner accepts the point which is made by my learned friend in paragraph 39 of Mrs. O'Hanlon's supplementary skeleton, that we are concerned with decisions taken prior to the coming into force of Section 3 of the retained EU Law Revocation and Reform Act 2023. Mrs. O'Hanlon's request was made in April 2020 and the Executive refused it in May the same year. The Commissioner's decision notice was issued in September 2021 and Mrs. O'Hanlon issued her appeal to the First-tier Tribunal in February 2023. So we do take the point that the 2023 Act had not yet come into force. The regulations must therefore be read in light of the directive. We say, however, that does not aid Mrs. O'Hanlon because nothing in the directive requires the reading for which Upper Tribunal Judge Citrin gave. If I could ask you then, my lords, to turn up tab 2 of the authorities bundle, which is the 2003 directive. This is page 8.
Sorry, page
8, my lord. Now, starting with the recitals, the recital, 5th recital, we say is material. The purpose of the 2003 directive was to ensure that the provisions of EU law were consistent with the Aarhus Convention on access to information, public participation in decision-making, and access to justice in environmental matters. None of the parties today will be inviting you to look at the convention. It's not in the authorities bundle, and we say it doesn't take matters any further than the directive does. For the sake of completeness, however, I will give you a reference later on when we look at Evans, because Lord Neuberger in Evans refers to Article 9.1 of the Convention.
Is that the relevant part?
That's the relevant part. Well, I can give you the reference now if you like, but I'm going to take you to Evans in any event.
It's 9.1 anyway.
That's correct, yes,
Thank
you. The next recital, recital 8, says that it's necessary to ensure that any natural and legal person has a right of access to environmental information held by or for public authorities without having to state their interest. Recital 9, it's also necessary that public authorities make available and disseminate environmental information to the general public to the widest extent possible. And recital 10 below that similarly stresses the importance of giving the term environmental information itself a broad definition. Recital 13 over the page on page 9, we do say this is important. It's also necessary that public authorities make available and disseminate environmental information to the general public to the widest extent possible. Excuse me, recital 13, I've read from recital 9 again. Recital 13, environmental information should be made available to applicants as soon as possible and within a reasonable time, and having regard to any timescale specified by the applicant. Recital 16, the right to information means that the disclosure of information should be the general rule and that public authorities should be permitted to refuse a request for environmental information in specific and clearly defined cases. Grounds for refusal should be interpreted in a restrictive way, whereby the public interest served by disclosure should be weighed against the interest served by the refusal. The reasons for the refusal should be provided to the applicant within the time limit laid down in this directive. Now, one can see the first reference here to the public interest balancing exercise, but the recital itself gives no indication as to the timing, other than that it should be done within the time limits of the directive. Lastly, recital 19, applicants should be able to seek an administrative or judicial review of the acts or omissions of a public authority in relation to a request. Now, it's notable because we're going to come to it in a little while, but the recitals are otherwise silent on the specific issue of reconsideration, which is set out in Article 6.1. There's no suggestion in the recitals that reconsideration, as opposed to review, on the other hand, should be carried out in any particular manner, or that there is any particular weight to the distinction. Turning to the scheme of the directive itself, Article 1A states that the objectives of the directive are to immaterially guarantee the right of access to environmental information held by or for public authorities. And Article 2 over the page, paragraph 3, provides that information held by a public authority shall mean environmental information in its possession, which has been produced or received by the authority, by that authority. Article 3, paragraph 1 on the same page, member states shall ensure that public authorities are required, in accordance with the provisions of this directive, to make available environmental information held by or for them to any applicant at his request and without his having to state an interest. And reiterating the point, or stating the point that was made but also echoed in the recitals, Article 3, paragraph 2, small paragraph A, subject to Article 4, the information shall be made available to an applicant as soon as possible, or at the latest within 1 month after the receipt by the public authority of the applicant's request. Over the page, we look at Article 4. This lists the various exceptions to the right of access to environmental information. The first of which is material here, Article 4 and paragraph 1A. A public authority can refuse a request if the information requested is not held by or for the public authority to which the request is addressed. That makes, we say, the date upon which information is held of particular importance. And towards the end of Article 4, subparagraph 2, which is over the page, just below the second finding, it says, the grounds for refusal mentioned in paragraphs 1 and 2 shall be interpreted in a restrictive way, taking into account for the particular case the public interest served by disclosure. In every particular case, the public interest served by disclosure shall be weighed against the interest served by the refusal.
If the authority hasn't got the information, how do you apply the public interest test?
You don't, quite simply. Or rather, it's quite clear which way, another way of putting it is the public interest test weighs very clearly in favour of non-disclosure because there's, of course, nothing to disclose. It is, as we see in Mr. Koppel has a reading, public interest test should be applied in such a way as to take into account information which was received later on by the public authority. And we say that's a misreading, and there's certainly nothing in the directive or the regulation which requires such an interpretation. To the extent, we'll come on to the actual public interest balancing test under the regulations, 12, so paragraph 2 in the regulations, and we can look at the wording of the language then, my lord. If I may ask your lordships now to look at Article 6, over the page on page 12, Article 6, paragraph 1, member states, this requires member states to ensure that any applicant who considers that his request for information has been ignored, wrongfully refused, whether in part or in full or in part, inadequately answered or not otherwise dealt with in accordance with the provisions of Articles 3, 4 or 5, has access to a procedure in which the acts of the omissions can be either reconsidered by that or another public authority, or reviewed administratively by an independent and impartial body required by law or established by law. Any such procedure shall be expeditious and either free of charge or inexpensive. It's worth noting, pausing to note at that point, Article 6.1 doesn't require a member state to provide for reconsideration or internal review by the public authority itself.
And is this right, that the Information Commissioner is the independent and impartial body established by law?
Yes, Madam.
So that's one of the alternatives.
That is one of the alternatives, and in the United Kingdom under the regulations, a belt and braces approach has been adopted because you have both Regulation 11 and you have Regulation 18, which cross-references Section 50 of the Freedom of Information Act, which provides for the right of complaint to the Commissioner. And Article 6.2 provides for the tribunal's oversight, or the judicial oversight. Just to pause
If
on...
reconsideration goes beyond review, if Regulation 11 doesn't provide for reconsideration in that sense, that isn't non-compliant with Article 6.1 because it suffices that you have, in this instance, the Information Commissioner procedure alone.
Yes, we would agree with that. And in fact, when we come on to the DEFRA case, Burkitt, you see that my Lord Justice Sullivan had addressed this point in his discussion that supported his analysis for why you could rely on acceptance late. But just to take up the point in relation to the different availability of avenues contained within Article 6.1, it's not surprising that the directive doesn't attach any particular weight to the process of reconsideration specifically by the public authority itself, since that's just one way of achieving the procedure required by Article 6.1. And then we say further on in Article 6.2, the review procedure, in addition to the review procedure referred to in paragraph 1, member states shall ensure that an applicant has access to a review procedure before a court of law or another independent and impartial body established by law, in which acts or omissions of the public authority concerned can be reviewed and whose decisions may become final.
And in this case, that's the tribunal.
That's the tribunal. So the Commissioner says that nothing in the directive contains any requirement on a member state to ensure that the review procedure, and that's the description that Article 2 gives of the procedure in Article 1, that the review procedure under Article 6.1 must be undertaken in a particular manner, or with particular requirements. Mr. Lockley, my learned friend for Mrs. O'Hanlon, attaches weight to the fact that Article 6.1 uses reconsideration where it's a public authority and review where it's an external body. However, not only does Article 6.1 fail to provide any flesh to that distinction, it also allows for a decision to be reconsidered by another public authority, and it twice refers to the procedure overall as a review procedure. So it's just underlining the point that if there was such a hard and an important distinction between reconsideration on the one hand and a review procedure on the other, it's striking that Article 6 overall does not lay any particular weight on it. If there was any intention for the EU bodies that reconsideration meant in effect an entirely fresh decision with the engagement of any exceptions and the balance of the public interest to be assessed by that later date, no such language was used to indicate such an important step. That is all I have to say on the directive. And now if I could ask your lordships to turn up tab 3, which is the regulations themselves. This begins at page 15 of the authorities bundle. There's nothing material in Articles 1 over the page at Article 2. This is page 16, is interpreted. There's nothing there that I would wish to take you to except for the bottom of, right at the very end of Article 2, which is the bottom of page 18. Except as provided by this regulation, expressions in these regulations which appear in the directive have the same meaning in these regulations as they have in the directive. So whether or not we are concerned with the operation of Section 3 of the 2023 Act, for example, it still remains the case that Parliament has required that the regulations, any undefined terms, be read in accordance with those in the directive in any event. So you still have to look to the directive in the event that there are any undefined terms for assistance. It doesn't take you very far, but it shows that the issue of any issue as to the supremacy of EU law in this case is somewhat secondary, we would say. Looking over the page at Regulation 3, this is just laying the groundwork for the second issue, which my learned friend Mr. Taboria will take up. Paragraph 2 of Regulation 3, environmental information is held by a public authority if the information is in the authority's possession and has been produced or received by the authority, or is held by another person on behalf of the authority. Then if I could ask you to turn up page 22 of the authorities bundle. This is Regulation 5, the duty to make environmental information available on request. Paragraph 5(1).
Just notice in passing, Regulation 4, which is this other aspect of the directive, dissemination of environmental information.
Yes, ma'am.
Regulation 4.3 brings in the Regulation 12 exclusions.
Yes. So, for example, if one of the exceptions under Regulation 12 relates to information in relation to the course of justice, so the legal professional privilege.
We're focusing on a case where we're dealing with the scheme for dealing with requests.
Yes.
But there is this broader obligation on local authorities to disseminate environmental information, irrespective of whether or not a request has been made.
Yes.
It may be important to have a look at the implications of provisions such as Regulation 12 for what could otherwise be a very onerous obligation.
Yes, although in fairness to what I expect my learned friend Mr. Lockley will say for Mrs. O'Hanlon, Regulation 4 is a continuing duty.
Yes, I understand.
It's something the public authority keeps on doing and undertakes to do progressively over the course of time. But as your lordship has noted in relation to Regulation 4, paragraph 3, Regulation 12 provides exceptions to that. So, for example, if you hold privileged information, that won't be required to be disclosed.
But the same public interest balancing exercise falls to be applied.
Yes.
Presumably, the practicality of this is to avoid people having to make requests.
That's very much the purpose of Article
In
40.
fact, it has the potential to alleviate the burden on public authorities, because if they have disseminated the information, they're much less likely to have to administer a request.
That's correct. Although the corollary of that is that when you receive a request, you are required to balance the public interest factors by reference to specified information, specified in scope and time and delineated by the wording of the request. Whereas if you have to apply Regulation 4 and the corresponding duty under FOIA to all the information which you hold, it becomes a much larger exercise. For that reason, public authorities, the release of information under Regulation 4 tends to be more slower because it proceeds at a slower pace. And if people want particular items of information, they can of course ask for them.
And in 4.1a, the word progressively indicates that this is a continuing obligation.
Yes, Madam. That's correct. If I could ask you then to turn back to Regulation 5, Paragraph 1. So we have subject to Paragraph 3, and in accordance with Paragraphs 2, 4, 5 and 6, the remaining provisions that was part and parcel of these regulations, a public authority that holds environmental information shall make it available on request. We say that the information held at the time of the request and the description of the information sought establish the scope of the request, and the public authority then has to decide whether it's obliged to disclose that information by considering the application of the exceptions in Regulations 12 and 13. So the application of exceptions, which we'll come on to when we look at Regulation 12, only arises in respect of information which is captured by the request. The application of exceptions can't be used to expand the scope of the request. Regulation 5, Paragraph 2, information shall be made available under Paragraph 1 as soon as possible and no later than 20 working days after the date of the receipt of the request. So that is consistent with and indeed required by the directive, and you will recall the directive which, the recital in the directive which stresses the importance of information being made available as quickly as possible, as soon as possible.
We've lost the reference to the timescales specified by the applicant, haven't we?
Yes, we have lost the reference to the timescale specified by the applicant. However, the applicant's request as to the manner and form in which the information may be provided is dealt with in Regulation 6. So the applicant's wishes as to the way, particular format in which information may be provided is still something that the public authority has to have regard to. The next part of the regulations which I would like to take you to is Regulation 7, that's on page 24. This permits a public authority to extend a period of 20 working days to 40 working days if it reasonably believes that it's necessary to do so. If it believes that the complexity and volume of the information requested, this is paragraph 7, Regulation 7, paragraph 1. If it reasonably believes that the complexity and volume of the information requested means that it is impractical either to comply with the request within the earlier period or to make a decision to refuse to do so. And that's it's a point to bear in mind. The more cumbersome a request becomes, the more opportunities the public authority will have to be able to take more time to deal with it. Similarly, we look over the page of Regulation 8. There is provision for charging under Regulation 8.1. The public authority may draw up a schedule of costs and charge for information. Of course, that has to be done under specified circumstances because of the original scope of the directive is, or the purpose of the directive is to make information available free of charge. So Regulation 8 is an exception to that. But it tends to come into play, and public authorities are certainly more likely to do it where they perceive that the work involved in responding to requests justifies costs being applied in certain circumstances. Now, ordinarily I would take you in the sequence of matters, I would take you to Regulation 11, but actually it makes more sense to look at Regulation 12, because this is what before we come on to Regulation 11, because this is what a public authority must do when it's considering a request. Regulation 12 is to be found on page 30. It sets out the key exceptions to the duty to disclose environmental information. Regulation 12, paragraph 1, provides materially that a public authority may refuse to disclose environmental information requested if an exception to disclosure applies, use present tense, under paragraphs 4 or 5, and in all the circumstances of the case, the public interest in maintaining the exception outweighs the public interest in disclosing the information. And the present tense explains why the relevant date for considering the application of any exceptions in the balance of the public interest is the date of the public authority's refusal rather than the date of the original request. Because the question, as my learned friend Mr. DeBory will come on to when he deals with his ground, is our second ground. When an authority receives a request, the question of what information is held is determined by the date of the request. But the application, we say, of the balance of the public interest and any exceptions, or rather the other way around, the application of any exceptions and the balance of the public interest fall to be decided by reference to the date of the public authority's decision. And that is reflected in the language, the tense used. A Regulation 12.4a is a key exception that helps to illustrate the correct approach, because it states that for the purposes of paragraph 1a, a public authority may refuse to disclose information to the extent that it does not hold that information when an applicant's request is received. So if you receive the request on the 1st of March and you consider it on the 7th of March, it doesn't matter that you hold the information when you are considering the request. What matters, according to the terms of Regulation 12.4a, and that it is lawful to refuse the request because when you received it, you didn't hold the information in question.
The use of the word refuse is odd if you don't have it. I mean,
Yes.
if you ask me to disclose your brief fee, I will say, well, I have no idea what it is. I don't know what it is. I'm not refusing, I just can't.
Yes.
Refuse suggests that you have an option and you choose not to disclose.
Yes, I certainly agree with that analysis. It rather reflects the draftsman's choice in making Regulation 12, paragraph 4, a list of exceptions, there which rather fits better with your lordship's analysis. Refuse does seem an odd way of framing something if you don't have it.
But this goes back to the directive, Article 4, the same language of discretion, may provide and refuse, you find there.
Yes, that's correct. Well, of course, a public authority always has the option to disclose it outside the terms of regulations or the Act for you. And that's the inherent discretion of any public authority, subject, of course, to often there are other statutory requirements which prevent them from disclosing information. But as a general rule, if a public authority is not constrained by some other enactment from disclosing information, they can always take the step of disclosing information outside the scope of the Act.
But if I follow what you're saying correctly, when we turn to Regulation 12.4a does not hold, that is considered as at the date when the request is received.
That's correct.
But the public interest test element applied to that is considered
At the later date.
at the later date when the decision is taken.
That gives rise to Mr. Coppell's, don't say flight of fancy, but speculation. The learned author suggests that the difference between those two dates means that it is possible for the public interest factor to justify the disclosure of information not held at the time of the request. We say that's not a proper reading of these regulations.
Well, say, forget 12.4a for the moment, say you've got a case within 12.4b, your submission is that the public interest test would still be looked at as at the date of the decision.
Yes, that's correct.
That you could take into account information that you're aware of as at that later date. Or circumstances, I'll drop the word information.
Yes, you are, well, it's entirely proper because of the scheme of the regulations and the scheme of the directive is to enable the public authority to have the time to consider a request. And that, if it helps, makes sense why there is a distinction between the date of the request on the one hand and the date of the, say, original refusal was the term that gets adopted by the Supreme Court in Evans.
Well, if just looking at B, why shouldn't it instead be looked at, the public interest test, as at the date of the request?
Because
Is it about 12.1b that mandates that it's looked at as at the later date?
because the retrospective exercise is itself sometimes a burdensome and difficult exercise for a public authority to undertake. It's one thing to ask a public authority to say which information was held on the 6th of March or the 1st of March. It's another to require the public authority to go back and think about what the situations, the full range of circumstances and the potentially applicable exemptions were as of that particular date. That requires more work for the public authority. We don't say that's a
Even if they're adhering to the strict timescales?
even if they're adhering to the
Is
tricks.
there any authority on this point that you apply the public interest test as at the date of decision?
As at the date of the decision, yes, I will take Evans and Montague are the key decisions.
But you've got to decide an exception exists before you get to the public interest test anyway, haven't you?
Yes, and you decide a decision whether an exception applies at the same time at the date of the refusal or the date of the decision.
Which is, in other words, the test in Regulation 12.1 has two cumulative elements, and if you don't get past A, there's B simply never arises.
That's correct, Arnold.
So you're saying if we look at the exceptions in 12.4, forget A for a moment, you're saying if we look at B to E, they're all applied as at the date of the decision?
They are all applied at the date of the decision. And the other exceptions in it's not just 12.4, it's also 12.5. That's where a public authority may refuse to disclose information to the extent that its disclosure would adversely affect, let's take 5A, international relations. Now, perhaps when the request was originally made on the 1st of March, there was no risk to international relations, but by the time that the public authority comes to consider the matter, on the 15th of March, war has broken out. That would justify the public authority taking into account the supervening war into account in the balance of the public interest, notwithstanding that there was no war when the request was made.
So looking at the pattern of these provisions, it's just 4A, which in terms of the exception is explicitly looking at the date when you receive the request.
Yes, it's sui generis in that respect. It's not like the other provisions because it has a specific date tied to it. But that is, I expect Mr. Tavori will say that is consistent with the scheme scheme of the regulations and the scheme of the directive. If I then could ask you to turn to regulation, at last, regulation 11, it's the preceding page, 29. Regulation 11, paragraph 1, subject to paragraph 2, an applicant may make representations to a public authority in relation to the applicant's request for environmental information if it appears to the applicant that the authority has failed to comply with the requirement of these regulations in relation to the request. That is technically a condition, although we're very struggle to see how it could ever be justiciable. The obligation, however, is on the public authority to respond. There's also a timescale, paragraph 2. Representations under paragraph 1 shall be made in writing to the public authority no later than 40 working days after the date on which the applicant believes that the public authority has failed to comply with the requirement. The nature of the applicant's belief is not a point which I regret to say has been explored by the case law. It's possible to think up various scenarios in which the applicant might have beliefs which don't necessarily arise from the facts, but if we're dealing with, in any event, in the ordinary course of events, it will be because the applicant has received a decision from the public authority. In the paradigm case here is a refusal to disclose the information. Regulation 11.3, the public authority shall, on receipt of the representations and free of charge, A, consider them and any supporting evidence produced by the applicant, and B, decide if it has complied with the requirement. So the basis of the request, or the basis of the representation procedure, requires that the applicant, if it appears to the applicant that the public authority has failed to comply with a requirement. And regulation 3B is requiring the public authority to consider, in light of the representations and evidence received, whether it has decide if it has complied with the requirement. And our submission is that to decide if it has complied is backwards looking, which is to the date on which the applicant believes the public authority has failed to comply, which is in effect the decision. Now, as I've said, in most cases, the failure in question will be the public authorities, or the alleged failure, will be the public authority's refusal to disclose information to the applicant. In such a case, Regulation 11.3b requires the public authority, having considered the applicant's representations and evidence, to look back to its earlier refusal and decide if it complied with its requirements on that date. We say that is the natural and ordinary meaning of regulation and not in any way ambiguous.
Suppose that the requester gets all the information that they have requested, but it's taken 60 working days for that information to be provided. And the requester says, you haven't complied with these regulations because although I got information, I got it late. How does that then work in terms of Regulation 11, and in particular Regulation 11.5?
Well, that means that if you gave them all the information but you took too long, first of all, one questions why the applicant would then bother to complain, but let's suppose that the applicant does complain. The public authority would then have to decide whether it's complied with a particular requirement to provide it within a particular time.
And it would say, no, we didn't, we were late.
Yeah. So they put the public authority holds up its hands, then it has to notify Regulation 11, paragraph 4, it has to notify the applicant of its decision as soon as possible, and again, later than 40 working days. And where it's decided, as in the scenario that it has failed to comply with the regulations in relation to the request, it has to include a statement of its failure to comply, the action it's decided to take to comply with the requirement, and the period within the action is to be taken. It seems to me in that situation, my lord, it can say, yes, we failed to comply with the requirement to provide the information within the particular timescale. However,
there's no action that we now need to take.
well, one might say for the Commissioner, of course, the Commissioner is keen to prevent future failings. So the public authority could, within its discretion, decide that we will do better next time and put in place its procedures to, if the delay resulted from a particular error, then that might be remedied, and they could indicate the period. But yes, in the normal course of events, the public authority might say, we've given you the information, there's nothing more we can do, or we don't propose to take any further action. Just while I'm on Regulation 11 in its meaning, you have the reference in paragraph 28 of our replacement skeleton argument to the decision of Upper Tribunal Judge Mitchell in Maritzi. Perhaps if we could just go there quickly. I hate to take you out of the swing of events, but it is rather convenient to look at that now. It's Authority Bundle tab 8 at page 225. The Upper Tribunal is here concerned with the interpretation of section 50, subsection 1 of FOIA. In section 50, subsection 1, Parliament uses the present perfect simple tense to set out the nature of the Commission's tasks. See the emphasised words above. The present perfect simple tense denotes an activity that has been completed. When used in conjunction with an actor, in this case a public authority, it clearly informs the reader by whom the activity was completed. Ordinary linguistic canons of construction therefore indicate that Parliament's intention was for the Commissioner to inquire into the way in which a public authority completed the activity responding to a request for information made under FOIA, and the public authority, when it completed that activity in a qualified exemption case, will have addressed the public interest according to the current circumstances. But it's reinforcing my submission on the natural and ordinary meaning of Regulation 11. And then, of course, as we've looked at, perhaps we can look back to page 29 of the Authorities Bundle.
Sorry, that's tab. I misheard you, sorry.
Page 29 is at behind tab 3, Arnold.
You're back to
Yes, we're back to the regulations. Because it bears looking at again. My Lord Lewison asked me to address paragraph 5 of Regulation 11. But if we see the language, the tenses used, so where the public authority decides that it has failed to comply with these regulations, past tense. In relation to the request, the notification shall include a statement of the failure to comply, the action the authority has decided to take to comply the requirements occurred within the action is taken. And if there were any lingering ambiguity, we say there isn't any ambiguity, but if there were any, we say it's consistent in any event with the scheme and purpose of the regulations read in light of the directive. There's simply no textual basis for interpreting the obligation under Regulation 11.3b in the manner for which Mrs. O'Hanlon contends. And bearing in mind that Regulation 11.2 gives the applicant 40 working days to make representations, and Regulation 11 paragraph 4 gives the public authority another 40 working days to respond, you are looking at a total of 80 working days, or very roughly 120 calendar days. On Mrs. O'Hanlon's interpretation, a public authority would be effectively redeciding matters, taking into account, or rather redeciding the applicant's request by reference to matters as they may be potentially up to 4 months later. The engagement of various exceptions might well be different after a period. I gave you the hypothetical example of no war on the 1st of March, war on the 7th of March, public authority's decision on the 15th of March. Matters needn't be so dramatic. There are many different ways in which the public authority may shift and indeed shift over relatively short periods of time, certainly in periods of weeks. And similarly, the balance of the public interest factors for and against disclosure may have altered in that time. Requiring a public authority to consider any change in circumstances in the period and potentially address new exceptions plainly involves a substantial amount of work and gives rise to additional delays, which we say is contrary to the scheme and purpose of the regulations. Where public authorities face delays, they are more likely to rely on Regulation 7 to extend time for dealing requests. That means that applicants have to wait longer potentially to receive information. Alternatively or additionally, public authorities may also rely more often on charging for information in accordance with Regulation 8, or they may even result in public authorities relying more often on Regulation 12.4b, which is the manifestly unreasonable request. And that can involve where the work is simply too much. We say that Parliament cannot have intended such a degree of difficulty and uncertainty. This is the point made in my learned friend's skeleton for the executive, which cites the Supreme Court's decision and for Women Scotland. And we endorse that in our own paragraph 15 of our own skeleton. It's not in the bundle, but the reference is there. It's paragraph 60 of the Supreme Court's decision, where it said that an interpretation that produces unworkable, impractical, anomalous, or illogical results is unlikely to have been intended by the legislature. A further difficulty with the interpretation favoured by Mrs. O'Hanlon is that the public authority's reconsideration might result in the original decision being reversed, not because of any error in the public authority's compliance with the requirements of the regulations, but simply because the balance of the public interest has shifted. On the Commissioner's analysis, you look back to the decision you took on the 7th of March, and you decide whether you got it right by reference to matters as they stood at the 7th of March. But if Mrs. O'Hanlon is correct and Upper Tribunal Judge Citrin is correct, then you have to look at matters as they stand now, and you might potentially decide that even though you got it right on the 7th of March, matters as they now stand on the 9th of June, or let's put it within the statutory timeframes, within the 30th of March, matters as they stand as the balance of the public interest is simply different. Matters have changed. So therefore, the balance of the public interest favours the release of the information.
Well, suppose it went the other way. Suppose the change in the public interest favoured a refusal to disclose, but in fact the information's already been disclosed. Can you ask for it, have it all back again?
Well, that would certainly be a great difficulty, because of course once information has been released, it's released to all the world.
Well, take your example of war. When the authority initially provided the information, it wasn't going to harm international relations, but by the time the review takes place, it would.
Yes.
The cat's out of the bag by then.
Yes. Well, we say these are all reasons why these outcomes would be perverse, and Parliament can't have intended such perverse outcomes. There's an additional reading, and I don't mean to lay weight on this, it's very much a subsidiary point in my argument. But it's notable that the trigger in Regulation 11 for making a request for reconsideration is not one-off. It's whenever it appears to the applicant that the authority has failed to comply with the requirements of the regulations in relation to the request. It is potentially possible for you to make a second set of representations and to produce evidence on a reading of this in relation to an internal review. There's nothing in the express language, other than the time limit in 11.2 that it has to be within 40 working days. There's nothing within the express language of Regulation 11 which prevents you from making a further request or further representations. Now, if you're only looking back at your original refusal, then the benefit, or rather the grounds for saying that there have been fresh failure to comply with the requirement of regulations tends to dry up, because all the original points get addressed. But if every time you are making a fresh decision by reference to the public interest factors as they stand at the date of the internal review, by reference to circumstances which have changed, and by reference to new evidence which may have been produced by the applicant in relation to matters which didn't occur at the time of the request, then you are potentially making Regulation 11 a movable feast, or to use a different metaphor, a can that can be continually kicked down the road. These, of course, in some areas of the public law, these are quite familiar. For example, if it's very common in relation to immigration decisions. where you make a decision at one particular point and then 6 months later they make fresh submissions, so the applicant makes fresh submissions by reference to private and family life because circumstances have changed. And you have to redecide matters as they go. And that's appropriate in cases affecting private and family life, but we're dealing with the release of information, we're dealing with the extent of the burden which is being imposed on public authorities to deal with requests. And bear in mind that one of the key purposes of the regulations and the directive is not merely to make environmental information available as of right on request, but within a timely manner as soon as possible.
I'm not sure I've followed, and I apologise. So, as you point out, under Regulation 11, the applicant can make representations, and that may involve new material. First of all, is there any constraint on what those new representations may be?
There's no constraint, but of course the way in which Regulation 11, paragraph 3 is framed is the public authority is required to consider the representations
And supporting evidence, which may be, as you put it a moment ago, new evidence.
Yes, but it can only have, if the commissioner is right, it can only ever be in relation to the original refusal. So how much new evidence can realistically be produced in relation to a matter which is becoming increasingly historic over time? If, however, one...
So it could, but for example, forget 12.4a again. It could be new material going to the other grounds and also to the public interest balance.
That's correct.
There might have been a refusal already.
Yes.
And the requester wants to challenge that and puts forward new material.
Yes. And
if, for example, going back to 12.4a, your submission is this is not a route by which you can ask for a document which you didn't ask for in the first place.
That's correct. And the short answer in many of these cases is it's quite a common occurrence that the information is not held at the time of the request, but is later on held, or it becomes apparent to the requester through various means that there is a better way of asking for the information.
Well, you can make a fresh request.
Exactly.
That may very well arise if 12.4d is in play. That is to say, you've refused your request because the material is in the course of completion or not quite ready. That might arise in an environmental context. If, for instance, in relation to monitoring information, which is yet to be analysed and presented in a format that is intelligible, the requester has two solutions. One is to say, well, that exception didn't apply for whatever reason they want to raise, but the other is to wait for it to be complete and then make their application, make a further request.
Yes. Yes, my lord.
Same would be true under 12.5b. So if you're waiting for a trial to take place.
Wait for the trial to conclude. I should be clear, it's not only mischief by requesters, which is an issue in relation to Upper Tribunal Citrin's interpretation, it's also the potential for mischief by the public authority. And bear in mind that in this case, and I don't mean to suggest the executive, anything in relation to the executive, but also in Montague, which involved the Department for International Trade, produced a fresh decision notice approximately a year afterwards, and then did another internal review, which ended up being a full 18 months, I believe, was after the original request had been made. There is the possibility that public authorities might seek to delay their internal reviews to wait out a period of public controversy, might favour disclosure, and wait until after the war is over. Who knows how long wars last these days, but...
In Montague, that's a FOIA case, is it?
Montague is a FOIA case, yes.
Yes, where there's no statutory obligation to carry out an internal review.
That's
it was
correct.
A voluntary procedure.
Yes.
Yeah. Yeah. Whereas this only arises if it's under 11, it's triggered by a request by or representations made by the requester.
Yes, my lord. There's two further regulations I must ask you to turn up before we move on. The first is Regulation 14. Just to while we're passing over it on page 32, regulation 13 relates to personal data. It's its own separate exception, but it's relatively self-explanatory. Regulation 14 is on page 35 of your bundle. And it requires that where a request for information is refused, the public authority is required to issue a refusal notice stating the reasons, including any exceptions relied upon. And then at page 39 of the authorities bundle, Regulation 18.1 provides that the enforcement and appeal provisions of the Act, that is to say FOIA, apply for the purposes of these regulations as they apply for the purposes of the Act, but with the modifications specified in this regulation. They are, however, largely consequential. It's an important provision because when we look at Evans later on, it's the wordings of parts 4 and 5 of FOIA and sections 50, 51, subsection 1 and 4 and section 58 that leads the Supreme Court to conclude that it's the date of the original refusal that is the relevant date for considering the application of any exemptions under FOIA in the balance of the public interest. We have section 50 FOIA in the bundle, but we don't have sections 57 and 58. My main point here is that it's clear from regulations 18 that they apply. There's nothing in any of the various amendments which regulations 8 makes to the relevant provisions, 18 make to the relevant provisions of FOIA that make any material difference for present purposes. In other words, the machinery, the mechanics for the complaint to the Commissioner and review by the Tribunal are, for present purposes, essentially the same under the regulations as they are under FOIA. So that is relevant, even though Evans was not, in fact, dealing with, more complicated than that, Evans was dealing with both FOIA and the EIR, but it didn't address the relevant provisions of the EIR we're concerned with. So, but even though the part of Evans that dealt with FOIA is not strictly a binding, we say that the same reasoning applies.
So the reasoning you take from Evans, the point is?
The point is, and perhaps it might be easier to if we get to it in a moment, Michael, but the reasoning we take from Evans is that essentially Regulation 18 applies the same machinery.
Yeah, I got that.
And what the Supreme Court is saying in Evans is that it's those particular provisions of the Act, Section 50, subsection 1, subsection 4, and sections 58, which are the reasons why you take the date of the original decision in relation to FOIA appeals. There are three, I'm just mindful of the time, there are three cases to which I would like to take your lordships through to. I've been making my submissions as I go, but there are, and also in fairness to my learned friends, it will benefit them to have these matters considered by your lordships now. Three cases. The first is Burkitt, also known as Defra. The second is Evans, and the third is Montague. The case of Burkitt is behind tab 14 of your lordship's authorities bundle. That's page 372. This is a mercifully short decision of this court, in which it established that it was open to a public authority under the regulations to rely on an exception that it hadn't relied upon in its original refusal, or even at the time that the Commissioner had done his investigation and issued his decision.
Give me for a moment. You called it Burkitt. This is the case which we were given a law report of the other day, attached to someone's submissions. It's reported in the PTSR. Yeah.
Yes.
Okay. Sorry.
And I've just suddenly noticed, I'm grateful to your lordship pointing this out. I'm grateful, I just suddenly realised I'm not referring to the PTSR version, but fortunately the paragraph numbers are the same.
Yes.
Paragraph 4 of Lord Justice Sullivan's judgment, it's at page 373, summarises quite neatly the operation of the regulations. Among other things, he says, third sentence, the refusal must specify the authority's reasons for not disclosing the information required, including any exception relied upon. The person whose request has been refused may ask the authority to review its decision. The review decision must be notified as soon as possible and not later than 40 days after the request for a review. If the refusal to disclose is maintained, the person whose request is refused may apply for a decision from the Commissioner. You'll note, not that I would put too much on it, in fairness to Lord Justice Sullivan, but the judge refers throughout to review decision and a review, not a reconsideration. The only point really I take from this is that the Court of Appeal didn't think that there was any particular weight to the distinction. The next passage I would like to take you to is paragraph 20, which is at page 282. Essentially, Mr. Ficena for the appellants was arguing that the directive read properly meant that you couldn't rely upon exceptions after the date of the refusal or potentially any internal review. Paragraph 20, where Justice Sullivan notes 3 features of a purposive interpretation of the directive. The first is the relatively short time within which the initial decision to release or to refuse information, to release information with reasons must be made. The second is, and I emphasise this, the broad scope of the review process under Article 6. And the third is the balance that has to be struck between the public interest and the prompt release of environmental information and the need to avoid harms to other important public interests. Further down, paragraph 22, read paragraph 21 for yourself, but paragraph 22, with these factors in mind, Mr. Ficena accepts that initial errors or omissions in a refusal can be corrected in a reconsideration undertaken under Article 6.1. He draws a distinction between internal reconsideration and the next stage under the regulations consideration by the Commissioner. He submits that once the latter stages reads, the public authorities are unable to correct any errors or omissions in this refusal notice. However, this distinction ignores the fact that under the directive, the Member States do not have to provide a 3-stage appeal process under Article 6, internal reconsideration, administrative review, legal review. The first stage of the procedure may provide for reconsideration or administrative review. If administrative review is the first stage of the process, there would be, on the appellant's approach, no opportunity for a public authority to correct errors or omissions in its refusal. Such a limitation on the scope of the administrative review process would not be realistic given the potential complexity, both factual and legal, of some of the issues raised by the exceptions in Article 12.2. Superficially, I suppose it might be thought that the court's decision in Burkitt supports Mrs. O'Hanlon's reading, because since
Right, I can't hear what you're saying. You're competing with external interference.
I apologise, my lord, I will project that.
Not your fault.
Superficially, it might be thought that the court's decision in DEFRA supports Mrs. O'Hanlon's reading, since it shows that a public authority can rely on an exception up to even the point of appeal to the First-tier Tribunal. But we say that the Court of Appeal's analysis in Burkitt ultimately supports the remedial view, which is to say, if the public authority realises that its initial decision was an error, it is entitled to rely upon an exception. But the relevant date for the engagement of that exception and the assessment of the balance of the public interest is, we say, still the date on which the public authority originally refused the applicant's request. There's nothing in the court's decision in Burkitt which shows that the relevant date for deciding the engagement of any exceptions in the balance of the public interest is the later date. And
So I'm getting lost. I thought if you go back to square one, when they originally make their decision and they're looking at which exception applies, you look at the exception as of the date of the receipt of the request, but the public interest test as of the date of decision.
you look at the exceptions at the date of the decision.
Sorry,
I
you
apologise.
said previously that the exceptions in 12.4 are looked at as of the date of receipt of the request, I thought.
I apologise, my lord.
Or was that only 12.4a?
That's only 12.4a.
All the other ones as of the date of decision?
Yes, that's correct.
Okay, so the same analysis applies at this stage?
Yes.
Sorry, I just wanted to make sure.
And
I mean, what happens here in Burkitt is that DEFRA refused to disclose information because they say it's internal communications. And then it goes to the Information Commissioner, and DEFRA then appeals to the tribunal. And by that stage, it's twigged that some of this might be protected by legal professional privilege, so it wants to rely on that exception as well.
yes,
And that's the issue in the case.
yes,
It doesn't really tell you about when the question arises. The material that it refused to disclose is the material it refused to disclose originally. Either it was or wasn't protected by legal professional privilege at that time. So this case doesn't really tell you anything about the date, does it?
it doesn't really tell you anything about the date, but it does show, first of all, it tells you a lot about the directive and the way in which the directive is to be interpreted. And particularly, it's also the dog that didn't bark. Here was the Court of Appeal considering the scheme of the regulations and didn't indicate anything that the relevant date for deciding the engagement of any exceptions of the balance of public interest is a later date other than the point of original refusal. But perhaps the next, it might be best if we moved on to Evans, because this is the Supreme Court considering the environmental information regulations. This is tab 7, page 113 of the bundle, authorities bundle. This was, of course, a request for the then Prince of Wales's correspondence under both FOIA and the regulations. The main issue being the effect of a certificate or certificates issued by the Attorney General in relation to the requests. Now, I mentioned earlier Lord Neuberger's reference to the Aarhus Convention and the 2003 directive. If you turn up page 137, I apologise, this wasn't sidelined, it should have been sidelined. But at paragraph 22, the President of the Supreme Court summarises the operation of Article 9.1 of the Aarhus Convention. Specifically, he says that the Article 9.1 requires that the person who considers that a request has not been dealt with in accordance with Article 4 should be able to invoke a review procedure before a court of law or another independent and impartial body. Final decisions of the body should be binding. Could I also ask you to note at page 141. This might seem a rather abstract point, but it comes up later on in Montague, referring to the fact that paragraph 39 on page 141 of Evans, it said, in the course of the discussion, the Upper Tribunal considered the date at which the position must be tested and discussed it at paragraphs 46 to 62 of the determination. At paragraph 58, they stated that the reference date cannot be later than 28th of February 2006, which was the latest date by which any of the departments ought to have concluded their internal review of the decision to refuse Mr. Evans's request. So in Evans, the Upper Tribunal had concluded that the relevant date was the date by which a public authority, not the public authority had in fact concluded an internal review, but the date by which they ought to have done if they had stuck to the statutory timeframe. Now, the Supreme Court takes a different view, which we can see at page 150.
This is a case which involves, I think you said earlier on, both FOIA and EIR.
Yes.
Because under FOIA there's no obligation to conduct an internal review.
No express obligation.
There's nothing to stop you doing it. But, so here, there's the Supreme Court commenting on the EIR then.
It's the EIR, but also in actual fact, where the public authority also did an internal review under FOIA.
Yes, but there's no time limit.
Well, actually, if one refers to the Code of Conduct, the Code of Conduct issued by the Secretary of State under FOIA refers to doing internal reviews and gives a time frame.
Okay.
If I may just quickly take instructions on that point. Section 45. We believe that it does, but I've asked those instructing me to confirm. And in any event, if I could ask your lordships to turn to page 150. Now, what's important to bear in mind is that what the Supreme Court here is concerned with is first and foremost the validity of the certificate issued by the Attorney General and the power of the attorney to issue a certificate. It says at first glance, as to the first example, the likelihood of material change in circumstances at first sight seems almost vanishing slight given the very report. It's just between A and B. It is common ground in light of the language of sections 50 subsection 1, 50 subsection 4, and 58 subsection 1, which all focus on the correctness of the original refusal by the public authority that the Commissioner, and on any appeal of any tribunal report, have to assess the correctness of the public authority's refusal to disclose as of the date of that refusal. Same is true of the accountable person considering the issue of a certificate under section 53 subsection 2. So we say original refusal in paragraph 72 of Lord Neuberger's speech is unambiguous.
Just keeping up with you, you're emphasising, as I understand it, in line 5, the references to section 51, 54, and 58.
Yes, my lord.
Because the 50s are dealing with the function of the Commissioner, 58 is dealing with the function of the Tribunal.
That's correct, my lord.
Yeah. And your point is that these provisions relied upon by the Supreme Court weren't materially modified
By regulation.
18. This is the submission you're making earlier on.
Yes, my lord.
Okay.
And the Supreme Court's point is looking at this, well, they're noting it's the common ground between. They're noting it's common ground between the parties.
Yeah.
That it's the date of the original refusal. So that's a departure from what the Upper Tribunal had concluded.
They're not deciding it because it's common ground, but there it is.
Not- Yes.
Okay, thank you.
And then you have paragraph 73, where the Supreme Court allows that although question whether to uphold or overturn under section 50 or sections 57 or 58, a refusal by a public authority must be determined as at the date of the original refusal. Facts and matters and even grounds of exemption may, subject to the control of the Commissioner or the Tribunal, be admissible even though they were not in the mind of the individual responsible for the refusal or communicated at the time of the refusal to disclose, if they existed at the date of the refusal, or if they did not exist at that date, but only insofar as they throw light on the grounds now given for refusal. So that paragraph 73 is saying the Tribunal can take into matters which postdate the original refusal, but only to the extent that they throw light on matters as they stood at that time.
Oh, sorry, it says as they throw light on the grounds now given for refusal.
Well, yes, but that goes back to the point in Burkitt, and also the subtle reference in the midst there, when they say, and even grounds of exemption. That's a reference back to Burkitt and the fact that a public authority may rely on grounds relatively late in the day, even up to the point of an appeal being brought, subject to the control of the Commissioner and, of course, the control of the Tribunal. If I could just very quickly ask you to turn up one more group of paragraphs, just because it's helpful for your consideration. The next one is paragraph 100 at page 156 of the Authorities Bundle. It's again Lord Neuberger's speech. This is the passage, apologise again, it hasn't been sidelined. This is the passage where the Supreme Court deals with the environmental information regulations.
Can I have the reference again?
Oh, I apologise, my lord, it's page 156 and the paragraph number is 100. To explain, to put the matter in context, the regulations were also relied upon in Evans, but regrettably the Supreme Court did not have to decide or didn't find it necessary to decide the particular point which we're concerned with. But it does provide paragraph, I'm not going to ask you to read it now, but simply for your information. And also the page, over the page at paragraph 102, simply Lord Neuberger discussing the interpretation of Article 6(1) and the review procedure.
Interesting that in 100 he says that the requirements of Article 6(1) of the directive is met by the commissioner procedure.
Yes, not sure that's technically correct.
Well, that's the point we discussed earlier on.
Yes.
I think technically it is correct, because you don't have to have reconsideration by the public authority itself.
Oh, I apologise. Yes, I'm sorry.
It seems to be the same point.
Yes, it is the same point. I'm sorry. It's in 102. There is a reference. It's the second sentence in paragraph 102 over the page 157. The structure of Article 6 is that where the executive has refused a disclosure request and the applicant wishes to pursue the matter, 1, the executive must reconsider its refusal, Article 6, subparagraph 2. Now that's not correct. That's 6(1).
I think it's not correct in two respects.
If it maintains the refusal, the applicant must be accorded recourse to the judiciary, Article 6(2), and if he takes that up, 3, the decision of the judiciary is to be final. So, unfortunately, not an entirely accurate summation by the President on that point, but it's in any event relevant to show you that the Supreme Court had also considered Article 6 of the directive. If I can then ask you to turn up the third case, which is Montague, which is behind tab 10 at page 253 of the authorities bundle. This was another case in which there were sometimes substantial delays between the different stages, the initial request, the refusal by the public authority, in this case the Department for International Trade, and the internal review. Paragraph 54 of Montague, this is a 3-judge panel of the Upper Tribunal. Paragraph 54 was at the bottom of page 273, my lords. And the Upper Tribunal says here, paragraph 54, on the public interest timing issue, it has been settled practice, if not law, since the Supreme Court's decision in Evans that the balancing of the public interest factors in favour and against disclosure falls to be judged as at the date of the original refusal, then goes on to cite the passage in Evans, which we've just seen. Paragraph 55 on page 274, this conclusion on public interest timing was made in the context where, paragraph 39 Evans, the refusal decision may have been assumed to include the period up to when the public authority ought to have included its internal review of the decision to refuse the request. I venture to say, I apologise if I seem to quibble, as counsel for the department in Montague, and my learned friend Mr. Lockley was counsel for the Commissioner in that matter. I'm not sure that's entirely right. I should have thought original refusal was quite clearly indicating that the Supreme Court was concerned with the original decision. But it's certainly in the context is correct. The context is that the Upper Tribunal in Evans had thought that the internal review had to be taken into account. Paragraph 56 of Montague, it notes that Evans was followed and affirmed in the APPGR decision and also Marizzi, to which I've already taken your lordships to. I don't propose, for reasons of time, to take you through what it said in relation to APPGR. Unfortunately, Montague, the discussion is quite lengthy. and it doesn't really assist to take you what effect was decided. But in any event, it shows that there was as we can see, paragraph 57. It was not disputed in APPGR that the date of the public authority's decision refusing request would include any tenuous review of that decision by the authority. That, as the three-judge panel of the Upper Tribunal said in APPGR, was based on the prevailing orthodoxy. So you can see in another Upper Tribunal judge decision, they thought that the date of internal review should be factored in. Then over the page, effectively, you can see at paragraph 58 of the Upper Tribunal's directions to the parties. Paragraph 60, we do not accept the argument that the public authority's decision refusing the request includes the upholding of that decision following the internal review of that decision by the authority. It is an argument with no clear statutory basis, arguably stands contrary to the wording used by the Supreme Court in Evans, and lacks material support from APPGR because the point was not at issue in that case. We also do not consider that Maritzi decides the point conclusively in favour of the refusal decision, including the upholding of that decision on review. Jumping over to paragraph 62, and this is the point which has already been noted by your lordships, that the reason for the Upper Tribunal's analysis in Montague is because FOIA does not contain an express formal provision for internal review. And at paragraph 62, we see them discussing under section 51 the fact that the Commissioner has to decide whether a request for information made by a complainant to a public authority has been dealt with in accordance with the requirements of Part 1 of FOIA. We will shortly return to address the requirements of Part 1 include. The short point, however, is that they involve no requirement for a public authority to review its decision refusing the request. And I'm not going to ask you to read the rest of paragraph 62. We see over the page, paragraph 63, this is page 277, my lords. Paragraph 63, when read in context, the language of original decision in Evans therefore supports the conclusion that the competing public interests have to be judged at the date of the public authority's decision on the request under Part 1 of FOIA and prior to any internal review of that initial decision. And Evans certainly lends no support to the DIT's argument about the appropriate date here being the final decision of the public authority whenever so made. It's then paragraph 65 of Montague, this is skipping over the discussion of Maritzi and APPGR. Both decisions assist in pointing to the need to identify, if possible, the primary legal source. In the primary legal source FOIA, the obligation of the public authorities as to when it is to decide a request. As we have referred to above, the critical wording is that of whether the public authority has dealt with a request for information in accordance with the requirements of Part 1 of FOIA. The requirements of Part 1 of FOIA in terms of deciding a request for information are all concerned with the initial decision on the request for information. Nothing in Part 1 of FOIA imposes any obligation on the public authority to review a refusal decision and redecide it. Again, for reasons of time, but that is a crucial point for my learned friend Mr. Lockley, one which I think he rightly relies, because it shows, as far as the three-judge panel was concerned in Montague, because there was no statutory requirement to conduct an internal review, then considering for the Commissioner to consider whether the public authority had acted in accordance with the requirements of Part 1 of FOIA meant only looking to the original decision. And Mr. Lockley's argument, to summarise, is that because there is an express power for internal review in the regulations, then therefore you can take that into account in the balance of the public interest and the application of any exceptions by reference to the later date of the internal review decision. The question is even if FOIA did impose an obligation on a public authority to review a refusal decision and redecide it, we say that still wouldn't show that the proper date for assessing the balance of the public interest was the date of the internal review. Would equally be the case, and we say more coherent, for the balance of the public interest to be assessed by the public authority by reference to the date of its original refusal, or indeed, and that one of the difficulties with Montague is that the Upper Tribunal then makes so much of the point and indeed gives quite extended consideration to whether a right of internal review can be said to exist within the structure of FOIA. Because there is, as I've already mentioned, a code of conduct which is issued by the Secretary of State, and that includes a reference to directs that public authorities should provide an internal review. But these submissions were rejected by the Upper Tribunal in Montague. In fact, if we look forward, they're quite lengthy where it's been redlined. It's paragraph 79 to 83, which I don't ask you to read now, but it's where the Upper Tribunal addresses an argument made by the Commissioner in favour of taking into account internal review by reference to the Code of Conduct. But it's the key section that we say is important is on page 283 of the Upper Tribunal's judgment. Because this is the point at which the Upper Tribunal says, even if the Commissioner is right and there is a requirement for internal review, we can leave to one side whether the internal review contemplated by the Code is a full merits review in which all matters can be redecided, or is instead just a review of the processes by which the public authority came to its refusal decision. Paragraph 3 of Montague is the closest the Upper Tribunal comes to grappling with what we say is the underlying question. Even if FOIA imposed a requirement for internal review, why would that show that the date for assessing the balance of the public interest or the application of the exceptions is the date of the reconsideration decision rather than the date of the original refusal? In paragraph 84 of Montague, the Upper Tribunal refers to, in quotes, the central difficulty that sections 45 and 47 of FOIA don't impose any requirement on the public authority to undertake an internal review. But we say that that doesn't tell you anything as to why, even if a requirement did exist, why it would be appropriate to consider the balance of the public interest at the date of the internal review. So the key takeaway here ultimately is that Montague is not authority for the proposition that the relevant date of a public authority for assessing the balance of the public interest and assessing whether exceptions apply is the date of a review decision. Now, you've indicated to me, my lords, that you've read the decision of Upper Tribunal Judge Citron. I don't therefore propose to take you to it for reasons of time. Simply to draw the threads together, we say the proper construction of Regulation 11 is that the engagement of any exception under Regulation 12 or 5 and the balance of the public interest under Regulations 12(1)b fall to be considered at the date of the public authority's refusal, or the date by which a refusal should have been issued, whichever is the sooner. Upper Tribunal Judge Citron's error, and that of Mrs. O'Hanlon in her skeleton arguments, is that there is no textual support for treating regulation as...
Can you say that again? Sorry.
Upper Tribunal Judge Citron's error, and that of Mrs. O'Hanlon in her skeleton's arguments, is that there is no textual support for treating Regulation 11 as anything other than a backward-looking review provision. And although the three-judge panel in Montague devoted a considerable amount of attention to the fact that FOIA has no statutory provision for internal review, the fact that the regulations do contain a statutory provision for internal review is apt to mislead. As the Upper Tribunal noted, obiter in Montague, even if FOIA did contain a formal provision for internal review, you would still need to address the question as to the nature and intensity of that review, and you would still have to determine the relevant date for determining the engagement of any exceptions and the balance of the public interest. The failure of Upper Tribunal Judge Citron's analysis, which he shares with the learned Mr. Coppell, and the failure of Mrs. O'Hanlon's reading is this. There's no textual support for any of it, and it's contrary to the scheme and purpose of the regulations read in light of the directive, particularly the need to decide any exceptions within the applicable timeframe. Unless you have any questions, my lords, those are my submissions.
I've got one question, if I may. The requester requests information. They get a refusal from the authority to disclose the information. Can they go straight to the Information Commissioner, or do they have to go through Regulation 11? Would the Information Commissioner, in other words, say you haven't exhausted your potential remedies, I'm not going to entertain the application?
It's a provision, I believe, in, if one looks at section 50. Across the outside. Section 50 is at page 5 of the authority's bundle. Section 50 of the authority is the application for a decision by the Commission, and we say it's not materially different.
Oh, I see, not exhausted any complaints procedure.
That's correct, under section 52A.
So in practice, you've got to go through the Regulation 11.
Let me just, if I may just take instructions quickly, because it occurs to me that that's a reference to the Code of Practice. Is it different? If I may just quickly look at the regulation. Regulation 18 should tell us if that particular provision has been, I don't believe it is. I'm grateful to my learned friend. That doesn't quite answer it. For any reference, yes, my learned friend refers to 18, Regulation 18 4C, which is at page 39 of the authorities bundle, which says, for any reference to the Code of Practice under section 45 of the Act, there shall be substituted a reference to any Code of Practice issued under Regulation 16.1.
Which we haven't got, but it's not Regulation 11.
No, it's not Regulation 11. Seems to me an oversight.
Well, I'm just looking at 16.1 at the moment. Secretary of State can issue Code of Practice providing guidance to public authorities as to the practice which it would be desirable for them to follow in connection with the discharge of their function.
Yes.
So I haven't read further than that, but that seems to be a general code of practice.
Well, I regret that we don't have the Environmental Information Code of Practice, my lord, but
It's not specific to internal review.
it's not specific to internal review, but I dare say, without sight of its contents, that it probably indicates to applicants that they have the right to request to make representations to the public authority under Regulation 11.
Well, that's required by the regulations themselves.
Which is required by the regulations themselves. But if the Commissioner were to receive a complaint under this, then one would assume that the Code of Practice refers back to Regulation 11, and therefore the failure to use the Regulation 11.
Sometimes codes of practice just simply regurgitate what's in the legislation anyway.
Quite often.
It's not actually providing a new legal source.
Yes, my lord. It occurs to me that the easiest way would, over the short adjournment, would be to provide you with a copy of the Code of Practice in relation to under Regulation 16, and we can see what it says. I should expect, however, that it refers back to Regulation 11, so therefore the Commissioner would be reasonably entitled to refuse to take up a request to investigate a complaint, rather, if the applicant has not availed themselves of the Regulation 11.
It wouldn't be difficult to envisage circumstances in which the requester says, I'm fed up with this public authority, they're completely useless, no point asking for review, they're just going to obfuscate all over again, I'm going to the Information Commissioner.
Yes. It's also often the case that the Commissioner receives a complaint and then begins to engage directly with the public authority, saying, you haven't done this, you haven't done that. So the complaint is opened before an internal review is provided. But then if the internal review yields the satisfactory outcome, then of course the complaint falls away. And if the internal review doesn't yield the satisfactory outcome, then the complaint is already open and the applicant can make further submissions to the commissioner. The commissioner, practically speaking, there's a difference between when the commissioner receives a complaint and the point at which the commissioner opens an investigation into a complaint. And there may be quite a delay between those 2 points, depending on the circumstances.
Thank you.
Thank you, my lords.
Yes, Mr. Tabori next.
My lords, while we're rearranging, I too have been struggling to hear something. I wonder if closing that window would assist. Well, that might leave us stifling rather than deaf.
Trade-off this time of year.
Well, let's try it with the window closed.
Hopefully air conditioning.
No, probably stuck.
I was assuming that's possible.
Looks as though the window's stuck.
Been wedged like that for decades, I expect. My lords, I will make the submissions of the second appellant HSE. My learned friend Mr. Metcalfe has addressed you on the public interest balance issue. I'm going to address you on the held issue, if I can use that shorthand. As to factual background, a reference chronology is in our skeleton argument at paragraphs 3 to 22, so I won't go back through that. I will make my submissions on that single issue I'm concerned with reference to the judgment below, because the judge addressed a lot of the points of law, authorities, provisions that I need to address, and I will pick them up as he refers to them, and then lastly address some of the points that the judge didn't refer to, but my learned friend for respondent raises.
Yes.
We can pick up the judgment so far as relevant at paragraph 38, which is there's two separate core bundles. In ours, it's page 70.
Yes.
So paragraph 38 is simply stating what the information was. You may appreciate refreshing your memory about how it's described there.
Yeah.
And then 39 summarises what was the appeal response to that request, namely stating that it was outside scope of the statutory, that is Regulation 5, disclosure obligation, because it was created after the date of receipt of the request.
Yes.
And as quoted, you can see HSE relied in support of that proposition on Regulation 12.4a and on Koppel at that particular paragraph.
Just going back to 38, we're told these letters were referred to in a witness statement.
Yes.
What stage was that?
First instance. First instance, my lord, in the First-tier Tribunal.
First-tier Tribunal.
Yes. And I won't take you to 12.4a because my friend Mr. Metcalfe has already helpfully set out the scheme. But in terms of the practitioner's text that you can see was cited there, can I take you to that, please? That's in your authorities right at the end, tab 15, and it's page 391.
391.
My lord. So the relevant moment, a helpfully clear subtitle for the point. I'll read. The information which is to be communicated or to have its existence disclosed is 392, information held at the time when the request is received, irrespective of the date at which the information was recorded or came to be held by the public authority. FOIA and the EIR are to this extent retrospective. So we rely on, obviously, the fact that it's said with reference to both pieces of legislation. But then, if we could follow the superscript 71 in that first sentence down to footnote 71, you can see that the citation is not just of FOIA, but also the EIR 12.4a. So making clearer still that that principle applies to both. And then reading further on within that long footnote 71, under FOIA, the tribunal has no power on an appeal to require a public authority to disclose information first held by that public authority after its receipt of the request. And it cites OGC, Office of Government Commerce decision. And so could I take you next to that decision? That's in your authorities tab 6, and the relevant paragraphs are 106 to 7, page 94. So if you'd just like to read to yourselves 106 and 107, please. That's, of course, a FOIA decision, not an EIR one, but I have emphasised how in the commentary in Koppel it references both pieces of legislation. Whilst I'm on OGC, just to address a point made by the respondent in relation to the fact that what's said at 106 and 107 of OGC is obiter, which we absolutely accept. See paragraph 104. As you may have seen already from my supplementary skeleton, we say in response, see Mr. Justice McGarry in Brunner and Greenslade, which I've actually handed up, although it may be so trite that it doesn't need to be, but the relevant passage, seeing as it is before your lordships, can I take you to it, is 1002 internal page of the law report. And it's H, 1002H. The learned judge said, you have the point, I'm sure you know it, but the point is that there's a spectrum of obiter between a sort of passing remark on a matter that's not necessarily had full argument, and on the other end of the spectrum, something that's been fully argued, which...
Does it matter either way? We're not bound by the decision whether it's ratio or obiter.
No, absolutely quite. But to the extent my learned friend seeks to downplay its relevance, to the extent that it has relevance, being FOIA, not EIR, we say that's not a ground on which to do so. It was, as Justice Stanley Burton said in those start of that passage at 104, having heard full argument on this point from those leading counsel, I will say that. So we say that to the extent that it has relevance, and its relevance is supported by Koppel citing it in connection with this point, it's not lessened in its authority by being obiter.
No, but neither that decision nor Koppel binds us.
No, absolutely
The question is whether we find Mr. Justice Stanley Burnton's reasoning persuasive or not.
Absolutely, yes, and I certainly recommend it in that sense, for reasons that I will come on to. Coming back to the judgment, so in the core bundle, 40, we've got to cites my skeleton argument, citing OGC, and then 41 helpfully confirms the relevant date that we're talking about and rejects an argument that it should be a later date based on when the respondent chased her request. And then at 42 notes 12.4a, which I of course rely on. but says C12(1)(b), which provides that each of the Regulation 12 exceptions are subject to the public interest balancing test. And the judge quotes, at that point, quotes that the view expressed in Koppel that reconciliation of 12(1)(a) and 4(a) is that information acquired after receipt of the request may be disclosed if the public interest balance favours it. And I will make a few submissions about that. So the first point is that it's not clear how that can work. If you don't hold information, you don't hold it, and the public interest balance can't change that basic fact. The judge was, however, right that just on the face of the statute, 12(1)(b) applies the public interest balancing test to all the exceptions without accepting 12(4)(a). But that doesn't mean that the reality of a given request can be ignored, e.g. the fact that simply nothing is held. And the reconciliation, we would suggest, lies in 12(1)(b's in all the circumstances. So 12 is on authorities page 30, and I'm sure you've got it well marked by now. So those circumstances might take into account that you just don't have it, in which case such public interest balancing as you might perform would be a very perfunctory, non-balancing test.
In every case? If so, it becomes a dead letter.
Yes, effectively, one of the circumstances, if one of the circumstances is that you don't hold it, then it's not, yes, you don't effectively get into its balancing, but I mean, that's the only way to read it so as to, because the fact is that 12(4)(a) is not like Regulation 13 separate. It's not so sui generis, as my friend puts it, that it's outside the scope of the public interest tests. So it must be, it can only work if the in all the circumstances provision allows for the taking into account, as surely you must, that you don't actually hold the information. And that
there was no need to include in section 12(b) an exception for section for regulation 12(4)(a). In other words,
yes,
rewriting 12(1)(a) to say an exception applies under 4 or 5, and save in the case of.
yes, that would have worked, but the way they do it instead is to allow in all the circumstances of the case to apply instead. We see the same.
I still don't understand. In all the circumstances of the case, are you saying that's specifically focusing on 12(4)(a)?
Well, the case would be the request in question.
Yeah, but isn't that directed at all the exclusions?
Yes. I mean, and often it's sort of
It's a rather strange reading in all the circumstances of the case. So that it does the job of disapplying the public interest test. If you want to draft legislation like that, you wouldn't go about it in that way, would you?
Well, I don't know. There was certainly
to the UK draftsman. This stems from the directive.
Yes. Well, I was just going to say that in the directive you have in every particular case. That's in Article 4.2 on page 11.
Oh, just below H. Yes. Taking into account for the particular case, the public interest served by its disclosure. Is that the bit you have in mind?
It's within, so it's below Article 4.2. There's a sort of unnumbered paragraph beginning the grounds for refusal mentioned. Yeah, the second sentence. And hopefully, helpfully on the same point, can I refer you to the second of the two authorities that should be on your desks, handed up this morning? Ofcom and the Information Commissioner, a judgment of the CJEU. Paragraph 29 of that, not, it's 19 on the front. So they say there, with reference to Article 4.2 and in every particular case, such emphasis is intended to stress the interest.
What are we looking at?
Sorry, I'm referring you to paragraph 29 within this.
The Advocate General or the court or what?
The judgment itself, sorry. 1693 of the report.
29, yeah.
So the CJEU say, such emphasis is intended to stress that interest must be weighed not on the basis of a general measure adopted by national legislation, for example, but on the basis of an actual and specific examination of each situation brought before the competent authorities in connection with a request for access to environmental information made on the basis of the directive.
In other words, it's case specific.
Case specific, so it really doesn't take it much further, say,
I suggest you wouldn't use the words in all the circumstances. This is a general blanket provision excluding the operation of the public interest.
I can imagine various options were before the draftsman when transposing, but ultimately I would suggest that that is how the two reconcile, namely that the specific examination of each situation allows you to take into account that the information is simply not held at the date that you're required to consider what you do hold. And just regarding the relevance and weight of and utility of that paragraph I just referred to in Ofcom, in the Montague case in the Court of Appeal, Lord Justice Lewis said that the meaning of the different words in the directive was authoritatively determined by the CJU in Ofcom. So
In CJU
in Ofcom, the CJU,
this particular decision.
one, yeah. So I mean, perhaps that's a given that it's CJEU and it's European legislation, but helpful to have
Was
that.
that the case to do with aggregating?
That was its main, most
That's
famous
the
principle.
context in which he's saying that.
Hmm.
Yes.
Yes. Anyway, to come back to the judgment, and we're now at 43. The judge refers to footnote 74 of within passage of Koppel that he had referred to, which is on top of page 72 in our bundle, and it says, "This does not permit an applicant to make ongoing requests." But it's not clear why that would not be permitted if what is held at the date of the request becomes, under the influence of the public interest balancing test, what is held and what is subsequently acquired. Moreover, in the same footnote quoted in the inset quote of paragraph 43, Koppel, or the contributor, says, "We'll cover the situation where the public authority has first held information after receipt of the request, but before making its decision or decision on review, it would also appear to permit the Commissioner and the FTT to deal with information which is first held by the public authority, to deal with it's first held by the public authority after it makes its decision." So it seems to be implying that it's not even bookended by the internal review decision, and that it would very much be a sort of ongoing, rather than a point in time requirement.
Mr. Koppel doesn't give any authority to that.
No, absolutely. And yes, and a point made by, I think we can come on to it in a second. Yes, at the bottom of 44, if we could go on to 44 of the judgment. the final sentence was, given that HSE's response to the appeal expressly cited that section of Koppel, it seems fair to assume that HSE agrees with what is said there. It's slightly unfair because, as you've seen,
That point.
what we were trying to rely on was OGC and so on, not the fact per se that, but anyway, certainly didn't agree. And then at 44, so going to the start of that paragraph, the judge recognises the immediate problem with that construction, namely Regulation 5.1, which is the primary duty to disclose requested information, which only obliges the authority to disclose information it holds at the date of the request. We say on the face of Regulation 5.1, see it's 22 of the authorities bundle. So we submit that it so says because, as a matter of natural and ordinary meaning, in 5.1, the it, i.e. shall make it available on request, is referring back to the information that the public authority holds, and then available on request fixes the point in time. So, almost without regard to the somewhat extraneous authorities and others that you see, we say that that plain meaning means that what must be the assessment of what is held is to be done according to the date of the request. And for those reasons, the respondent is right at paragraph 37 of their supplementary skeleton to say that the Upper Tribunal, quote, was wrong at 42 to 44 to find support for that approach in the wording of Regulation 12.4a and the exposition of 12.4a given in Koppel. So there's effectively agreement between the parties on those points that I've just been looking at. Yet, as I've shown, at least so far as regards the judgment, that was the inspiration and basis for the tribunal's decision. So the concession does not actually leave much standing once that's conceded as not being defensible. 45 of the judgment. The judge says that the public interest balancing test applies at the date of the decision on disclosure, and reconsideration is such a decision, and therefore that was the date on which HSE had to consider the Regulation 12.4a exception and the public interest balancing test. That falls down, we say, on the terms of Regulation 11, which, as Mr. Metcalfe has shown, is backward looking. If I could just turn you briefly back to it, it's on page 29 of the authorities. So this is the references at 11.1 and 11.5 to has failed to comply with a requirement. And in 11.1, may make representations to a public authority in relation to the applicant's request. So it's concerned with that rather than being a fresh request or amounting to one, which is what it would become if a de novo assessment of what is held were required. And then just going back to the judgment. So 45, as I say, holds that Regulation 11 is a decision, and therefore it's a decision to which.
Question.
Yes, of
Going
course.
back to your submission on 11.1,
Yes.
was there, were there representations under 11.1 relevant to the A mark contravention notices we're talking about, which is what this
Yes.
debate now hinges on?
Yes.
Were there any such representations which engaged 11.1?
Do you mean, my lord, reference to A mark
Yes.
letters? No. No.
So this all happened after the event.
Spotted in the witness statement.
It was spotted in the witness statement for the purpose of the First-tier Tribunal.
Yes.
I think there are criticisms of the way in which the FTT judge dealt with it, but it really sprang to life in the Upper Tribunal.
Yes. Yes, effectively. Yeah.
And as I understand it, the jurisdiction of the FTT is to consider errors of law or to re-exercise discretion.
Yes.
The jurisdiction of the Upper Tribunal judge was limited to considering errors of law.
Yes.
So one question that's been going through my mind was, to what extent was this all triggered by under 11.1 in the first place?
Yes, it's a good question, my lord. My recollection of the hearing is that,
Particularly when the Upper Tribunal judge makes his analysis turn not on paragraphs 1 to 11 of the original request, but the opening words.
exactly. I was just
I asked myself, if the request had simply contained just the opening words,
yes.
what would have happened?
Well, my lord, these were my arguments that I lost on effectively as to whether those that sort of catch-all residual, which was somehow at the start, was mere introduction or actually saying everything. As in which case,
Whatever label you call it, is
Yeah.
it something which under this regime is meant to impose an obligation on the receiving body to provide information?
yes, exactly, my lord. Well, anyway,
Because if it is, then everyone could do that all the time.
yes, exactly. Yeah, but I think I'm just trying to say that's how I think it came up, is that the judge was against us on that. Therefore, these A-mark notices to a third party, not to the duty holder.
Was it actually raised as a point before the FTT? The A-mark point?
I cannot recall. I'm not
appreciate
sure.
it's in the witness statement.
Yes. Yes, I don't recall. Lord, I can check that over lunch, perhaps. So that's what just to complete the sort of survey of the judgment. So 46 briefly.
Just before we leave
Yes.
45,
Yes.
I'm afraid I have great difficulty understanding the last sentence of that paragraph, where the judge says that the 5th of August 21, the date of the reconsideration decision, is the date at which HSE needed to consider both the exception in Regulation 12.4a and weigh the public interest under 12.1b. 12.4a seems to me to be absolutely clear. It's the date of the request that is relevant. And I can't at the moment see how the Upper Tribunal judge interpreted that part of the regulations in a manner consistent with what he actually decides in this paragraph.
Yes, I am with you and grateful for the indication that you too see it to be quite out there, as it were. But to explain how the judge got there, it's this idea that whilst 12.4a is as clear as you say it is, because it's subject to 12.1b in the public interest test, the reconciliation says the slightly out there again footnote in Coppell is that the what is held at the date of the request principle, exception prima facie, gives way effectively if the public interest somehow balance justifies it, so that it no longer provides that bastion, if you like, and you end up having to disclose what you had subsequently acquire if the public interest demands it. And we say that that's completely wrong. But that's how the judge
So the public interest is not being required to disclose something which you didn't have at the relevant date. It's outweighed by the public interest in being required to disclose something which you have later on.
Yeah, perhaps they were saying...
If that's the right approach, I'm not sure there's a stopping point.
Exactly, which is why I referred to the footnote which said this could mean that the commissioner could look at what might have been acquired by that point, or the tribunal even. So it becomes this sort of rolling accompaniment to a regulator's attempt to discharge its duty.
There's no statutory bar on the number of times you can advance representations under Regulation 11.
Yes.
Or even if you can do it twice,
Yes, I mean, one of the,
as opposed to just simply making a fresh request.
which is the simple solution, and it's still not clear to us why that simply hasn't been done. But
It's also a very odd reading of the cumulative effect of paragraph 12(1)(a) and b.
just going to have a look at those.
Well, you've got to deal with them both.
Yeah. Yes, so 12(1)(a) is the engaged point, exception applies, and then the in all the circumstances public interest maintains. But then, as I said before, the only way linguistically can suggest that 12(1)(b) being engaged for 12(4)(a) doesn't works is to say that in all the circumstances of the case permits you to take into account the fact that you don't hold it. Otherwise, Regulation 5 effectively loses its meaning, and as well as the obvious impracticalities. And 12(4)(a) would almost become otiose, we say, because it would mean nothing to say it's not held. The requester would simply say, particularly if it was a request concerning an ongoing investigation, as was the case here, or an ongoing trial, or something in the course of completion, some sort of academic work, would simply say, what about now? What about now? And the original 12(4)(a) reliance, which supposedly reflects an important public interest, that's what these are adumbrating, would effectively be useless.
Because the potential for iterative consideration is contemplated by the opportunity to make further requests, which will then be judged at the point in time in which they arise.
Yes, insofar as there's thought for the justice of it and the balance reflected by the overall scheme, it must take into account the fact that it's not everything or nothing. You haven't got to keep alive your original request.
It's not that you got one shot in your locker.
Exactly. Yeah. And to develop this sort of practical side of things, and to borrow from my friend's reference to the For Women Scotland judgment, just to quote that important summary of that theory of construction, if that's what it's properly called. Unfortunately, not in our bundle, because mentioned it in my supplementary submissions, but to read it again: an interpretation that produces unworkable, impractical, anomalous or illogical results is unlikely to have been intended by the legislature. And that's cited originally because Mr. Lockley's skeleton referred to my making interorem arguments about sort of trying to scare the court from the consequences. But as the Supreme Court show us, that's an important and relevant approach to construing, to think about what would the impact be. And besides 12(4)(a) becoming otiose, as I say, one has to look at what would it mean for regulators. And again, I would say that this is a case in point. If HSE are conducting an ongoing investigation, and the exceptions they're relying on, originally under FOIA, latterly under the EIR, when they set themselves right, concern the prejudice to that, it would be nigh on unworkable if you're not just sort of gathering your information such as you hold it, thinking about which exceptions apply, and weighing the balance, but every day when however many new documents go online as the frontline investigators add them, you have to redo it, even all the way up to the statutory deadline that applies to you. So even when there's sort of hours remaining, you would be obliged to discharge your duties in relation to that new information. That cannot have been intended. It's certainly unworkable, impractical, and illogical.
been looking at 12.1, and 1B contains the public interest test, but there's also 12.2. Public authorities shall apply a presumption in favour of disclosure.
Yes.
That applies to all the exceptions, including 12.4a.
Yes. But it is.
Odd, isn't it?
It is odd.
Where is the presumption in I'm just looking for it in the directive?
I think it's in Article 4.
Just below H, there is a provision for interpreting the grounds for refusal in a restrictive way. That's not quite there.
The way the presumption is applied, I understand it, is if you have effectively a score draw in the public interest factors.
Everything else is equal.
Yes. And because of that, that provision 12.2 is ancillary to there having been a meaningful public interest balance.
It sits with the balance required by the public interest provision.
Yes, but
Including the directive, which
Yes.
helps us.
Lord, recital 16, I think.
Well, I thought
Thank you.
it might go back to
Information and disclosure being the general rule.
the general rule. Yes, in fact, you get another clue in the second part of the recital, going back to my Lord's question. Grounds for refusal should be interpreted in a restrictive way, whereby, and then and by that they mean the balancing exercise,
yes,
which is not actually an exercise in interpretation. It's application, but never mind.
yes. So the drafting's not
Get the
particularly
drift.
clear. Yes. I mean, I suppose another way of looking at it, my lord, is that if even if it's a sort of legal fiction, if you like, that okay, I am now per 12.1b applying the public interest. That's my starting point. But immediately I look and see that when I weigh the disclosure interest against the withholding interest, there can be no disclosure interest attaching or arising because there's nothing to disclose. So that way you could say you have properly applied the balancing exercise, but in the circumstances there is no disclosure interest. So it's not be easier simply to sort of exclude it altogether, but it works as a just on the face of the text. Having finished with the judgment really now, can I turn briefly back to Evans and Burkitt? I don't need to say too much because of the work's being done by my friend, but simply about the point that this isn't effectively the first. It might be the first time where the case has arisen because it's the first time a judge has taken up Koppel's footnote, if you like, but these aren't unexplored or unconsidered provisions. It hasn't all been FOIA before the senior appellate courts so far. So if I could just take you to Evans, which is tab 7 and page 150. So paragraph 73. So in this paragraph, Lord Neuberger says, as you see from the first sentence, that that the question whether to uphold or overturn a refusal by a public authority must be determined at the date of the original refusal. So that concerns the public interest test. But it's just relevant to note that in reasoning from that proposition, His Lordship refers to Burkitt, an EIR case, and he says at D, although Burkitt was a decision on the 2003 directive and EIR 2004 seems clear from the reasoning of Sullivan, LJ applies with equal force. So whilst not directly considered head-on as you're having to do, we do say that it is relevant that support for that view on the public interest test date is drawn from the EIR context as well. And then just briefly to look at Burkitt, it's
Sorry to
yes.
interrupt, but just before we leave that paragraph, in the middle is reference to Koppel. It's obviously an earlier edition. Just so as to help understand Roman 2, not now, but could we be shown the passage in Koppel which now deals with Roman 2? But as I say, I don't want to interrupt you now.
I can try, my lord. Yeah, I will certainly try. I mean, we've seen current Koppel where it says the same still.
If you can just tell us the paragraph number after that.
Yes, I'll confirm how it reads across. Absolutely, I'll make a note. Yes, and then so to follow it up to Burkitt, tab 14, page 372. Is where it starts. Page 383 for the relevant bit that I wanted to take you to. But paragraph 22 begins on 382, goes on to 383. So in this EIR case, as emphasised by Lord Newberger, Justice Sullivan, as my friend Mr. Metcalfe points out, says twice about the in the context of reconsideration that its function is correction. See the second line of 22 and the fifth line from the bottom of the paragraph, correct errors or omissions. That sits with what I and my friends have already said about the proper interpretation of 11.1, how it's backwards looking, how it's concerned with the original request, and how it's about compliance with a requirement, so correction. Not a new decision, considering new information held, and new balancing of the public interest balance. My lords, without wanting to carry on for the sake of it, those are my positive opening submissions. I may have something to reply on later. I don't know.
Thank you very much.
So I can help you any further.
Yes, Mr. Oakley.
My lords, I take it you'd like me to make a start before 1 o'clock.
I think so.
Yes, of course. Yeah.
My lords, there are two grounds of appeal that raise questions of statutory construction, and I say that the answer to those grounds lies on a close reading of the environmental information regulations in light of the underlying directive, and that close reading will be the core of my submissions. You will appreciate from my skeleton argument that I say there is in effect a single answer to both grounds, and that is that the updating construction I can call it that, which Mr. O'Hanlon contends, and which I say emerges from the regulations and the directive, answers both ground one on the timing of the public interest balance and ground two on the timing of the held question. And you'll see further from my skeleton argument, my lords, that I don't seek to rely on the Upper Tribunal's interpretation of Regulation 12.4a, which, alas for my client, is not sustainable in light of the directive.
So it's an updating construction of what?
Well, I'm using the phrase updating construction, my lord, as a shorthand for the interpretation which I'm urging on you, which is that when a public authority comes to consider whether to disclose information, both on the first occasion and in a case where it's received reconsideration representations under Regulation 11 on that second occasion, it is considering the information that it holds at that date. It is considering the application of exceptions under Regulation 12 as at that date, and it is considering the balance of public interest as at that date.
It's not really an updating construction. What you're really saying is there is a continuing obligation on the part of the public authority to consider the request, and that request must be considered at the various stages of the process laid down by the regulations.
Yes, I'll drop that shorthand if it's unhelpful, my lord. That is precisely what I say, and that on each occasion it is considering both of the relevant factors that are raised under grounds 1 and 2, what information is held, sorry, that's ground 2, but also the application of the exceptions and both limbs of that test, whether the exception is engaged and the balance of the public interest. All three of those matters are to be considered by the public authority at the date that it takes each of those two decisions. And we're postulating a case where it takes an initial decision, refuses the request in whole or in part, issues a refusal notice under Regulation 14, receives a Regulation 11 reconsideration request, and takes what I say is a fresh decision as to its compliance with the requirements of
But on this analysis, there's no difference between the approach you urge for Regulation 11 and what the authority would have to do if it received a fresh request.
That's correct, my lord.
So in terms of Regulation 11, what you say is that let's call it a review for the time being, reconsideration, is not a reconsideration or review of the authority's original decision. It's a reconsideration or review of the requester's request.
It is a decision as to whether the public authority has complied with the requirements of EIR. That's what Regulation 11 says. And I say, I'm anticipating my grammatical submission on the meaning of has complied. I say that is a decision which considers the circumstances as they stand at the time that consideration takes place.
It really means is complying.
Has complied and is therefore in compliance.
It is now complying.
Yes.
It's very present as well as past.
Well, that's what I say the particular resonance of the perfect tense is, as opposed to the simple past, the aorist. If the wording of the regulation had been whether it complied, then I would accept that Mr. Metcalfe's construction is the right one.
But again, if you were drafting Regulation 11, you wouldn't need to use the past tense at all, in any form.
Well, but the public authority is looking to what it has done and asking whether what it has done achieves compliance. So it doesn't disregard its past actions, and in many cases it will look at what it's done and say that continues to achieve compliance. I have nothing further to say. But the reason for the choice of a past tense is that it isn't simply starting afresh. It is reconsidering what it has done. But as the output of that reconsideration is to answer the question whether it is now complying, whether it has achieved compliance with the regulations. And that's the core of the submission in relation to the ground that Mr. Metcalfe addressed. But I also say that approach of looking at matters as they stand, as at the date of the public authority taking the decision, applies to the ground that Mr. Tabori addressed you on, because
The directive doesn't define what is meant by reconsideration.
it doesn't.
It's a word which can be applied in different ways. It can include, can't it, taking a decision again, but on the basis of the material that you already have.
Well,
That would be a reconsideration.
my lord, I say it is deliberately juxtaposed in contradistinction to the word review, because what the directive says is that it does provide for an either a reconsideration by the public authority, or Mr. Metcalfe's point, another public authority. I say that makes no difference, or a review, an administrative review, which is the Commissioner's decision. And we have numerous authorities telling us that the Commissioner's review decision doesn't take account of matters as they stand at the date of the Commissioner's review.
So you've got three options under that part of the directive. You can have a reconsideration or review by the same public authority. You can have a reconsideration by a different public authority, or you can have an administrative review by an independent person, such as the Information Commissioner.
Yes.
It is only in the first of those that there is any real possibility of new material in the possession of the original authority coming to light.
Yes, I would accept that. I do not
So
understand.
the interpretation of the regulations or the directive will depend on which of the various routes the member state has chosen to adopt, which seems odd. You would expect a uniform interpretation to apply to whichever route the member state adopts.
But my Lord's example is simply one of practicality. I mean, I don't quite understand the practicalities by which, in the hypothetical possibility provided for by the directive, another public authority carries out a reconsideration of public authority A's original response.
Well, it can.
That's a little
It can
difficult
if
to
it's
manage.
looking at the material that was before public authority A and asking whether, on the basis of that material, public authority A came to the right decision.
But so parking the question of what information is held, there's no reason that public authority B wouldn't know,
Exactly.
to take Mr. Metcalfe's example, that a war had broken out, and that therefore different circumstances applied to the balance of public interest test.
Well, that's obviously information which is, by definition, very external to the authority, as opposed to records which the authority has been keeping of what it's been doing.
Yes, but what one has to postulate, if public authority B is carrying out this reconsideration, that it would be empowered to ask public authority A what information it holds,
Why?
because that's necessary to answer the question.
Well, it is only if your interpretation is right.
Yes.
All right, well, shall we take a break there? Come back at 2 o'clock?
What lies appear